and shall coordinate issues of budget and policy making of constitutional commissions and other independent offices. Our first submission is that as we speak, there is no person who can execute the function of chairing cabinet committees. On the issue of constitutional commissions and independent offices, it is our humble submission that the Senate, having found the first petitioner guilty of violation of Article 160, then he cannot coordinate any functions with the judiciary effectively. The final thing, my lords and my lady, I would wish you to look at is the issue of political parties, particularly the role they have in policy formulation, political mobilization, and political democratization under Article 4 of our Constitution. The first petitioner was impeached by the Senate by a supermajority, which included members of his own political party and coalition. And I would want to draw you to a comparative analysis. When you retire, you will look at impeachment processes, which we have deponed to in the USA, in South Africa, and Brazil. But of instructive to note that closer home in South Africa, when Thabo Mbeki lost confidence of his own party, he resigned in 2008. And when Jacob Zuma lost the confidence of his own party, he resigned in 2018. So we respectfully submit, on behalf of the 9th respondent, that because of those two issues, conservatory orders cannot issue in this matter. Thank you, my lords and my lady.
Thank you.
Thank you very much, my lords and my lady. I want to take 2-3 minutes to delve into the reasons why we support the applications to set aside the conservatory orders, and we pray that the applications for those conservatory orders be dismissed. My name is George Murugara, appearing with the team for the National Assembly of Kenya. I begin by drawing your attention to the provisions of Article 118 of the Constitution, which actually deals with the public participation, which has been debated on and argued on in the House. And what I wish to draw the attention of the court to is sub-article 1, paragraph B, where Parliament is mandated to facilitate public participation and involvement in the legislative and other business of Parliament and its committees. What I wish to point out here is that not all business of the National Assembly or of Parliament has to undergo a public participation, because not all legislative duties nor other business actually does go through public participation. There are legislative processes in this country which need not be subjected to public participation, and also other business of the House which need not be subjected to public participation. What is important is the wording of that clause. The word "or" is not used, because if that was the intention, that everything that Parliament does has to undergo public participation, it would have been that in all legislative and in all other business of Parliament and its committees. However, I take you to Article 145, where there was public participation, in spite of the fact that there is no provision that there ought to have been public participation when the motion was actually moved. The correct position is that any member of the National Assembly, on attaining the threshold, can actually move a motion that the President or the Deputy President be impeached. Once that motion is moved, then it goes to chamber, it is debated, and it is voted on. So it is actually for Parliament to determine when to take such a motion for public participation. And I confirm that here, out of abundant caution, Parliament did take this motion to public participation on 2 days, as was even ordered by the court. And after the public participation, there was debate on it in the Parliament. It is this debate that takes into account the public participation, the views that were collected from the public out there. Then after that, a vote was taken, and therefore that process cannot be faulted. It cannot be said to have been flawed in any way, because in spite of the fact that there was no requirement for public participation, it was done out of abundant caution. Finally, there has been an argument that under Article 149, there ought to have been public participation regarding the nominee who was taken to the House for voting. And here we must draw the distinction drawn that this is not an approval. Approval on appointments comes under different articles of the Constitution. It's clearly provided that the appointment would be with approval of Parliament or approval of the National Assembly. Here, what took place was just a vote. There was no motion because there is no requirement for a motion. There was no debate because there was no requirement for a debate. Because what the law provides is the President nominates and the House votes. So the House sits, it's called to vote on the nominee on the basis that possibly the nominee is known to the entire country. And this is the reason why there is no public participation. If Parliament votes against that candidate, then the President would have to nominate another candidate and continue doing so within a span of 60 days until he gets a vote that is positive in his favor, not an approval. And we've said that approvals usually come under the Public Appointments Parliamentary Approval Act. This is the one that governs approval. This is the one which provides that there must be public participation in all public appointments when actually Parliament has to offer an approval. So finally, public participation here goes to Article number 1, where Parliament is exercising delegated powers of the sovereignty of the people of Kenya. It is presumed that when the Parliament votes, the candidate is known to the people of Kenya, and through their elected representatives, they have actually to cast votes which are in tandem with how their constituencies would have voted. So with these remarks, it is my submission that the nomination and the subsequent vote in his favor of Professor Kithure Kindiki was in order. It was actually appropriate and it cannot be faulted in any way, and therefore those conservatory orders should be removed. Thank you very much.
Welcome to QNet's world of new beginnings, where every sunrise is a promise of our commitment to you, your health, your dreams, your planet, and your community.
We are all here.
Doctor?
Dr. Willy Mutubwa and Mr. Hassan Noura. We are the 16th respondent. We are not with the other respondents. We are the IEBC. We are on our own, and to clarify matters to the court. Distinguished members of the bench, just for the record,
we hope that you are not sharing the minutes, these 5 minutes.
Your Lordship, it's just me. We are not sharing.
All right.
We've decided we will not distribute the time. I will try to cover as much ground as I can on the time allocated. If I need 1 or 2 minutes, you will be kind enough to add me, but I will try to cover. I know it's very late. Just for the record, we rely on the replying affidavit sworn on the 25th of October 2024 by Hussein Marjan Hussein, who is the CEO of the Commission. We rely on the written submissions dated 27th of October 2024 in response to the various petitions and the applications. We rely also on the written submissions dated 27th October 2024 with regard to the application for conservatory orders, as well as the bundles of the authorities. They are on record, Your Lordship, and we have filed and served the same. Your Lordship, on preliminary issues, it's good I came last because it was a learning experience for me, but also for preliminary issues. To the extent that a lot of the petitioners and even some aspect of the respondent dwelt on merit review of the petition, when this is an application for conservatory orders, those submissions should be disregarded by the court. That's the first one. The second aspect, even though the decision or the petitioners is an application for their rights in personam, the fact that the IEBC is here and this is a public interest matter, your decision will be a decision in rem. So the IEBC will be asking that you clarify for it the applicable principle and guide it on first principles. The third one, and which is very important, is it seems that there's a general agreement that the law that will apply, and this is the only thing that all the lawyers agreed on, is Munya. Peter Gatirao Munya is the standard for conservatory orders. We believe the court should adopt that standard. I will not dwell much on the prima facie case, but I will dwell a little bit on the nugatory aspect as it relates to my client. My client has been bundled up into these proceedings to establish the application for conservatory orders on two grounds, and this is important for the court to note this, on two grounds. The first one, the petitioner say that the IEBC has a constitutional role in filling a vacancy in the office of Deputy President under Article 149 of the Constitution. And this is important. The second aspect, they say that even though they have a role, they cannot discharge that role because they do not have the constitutional and legal capacity to function, as they don't have commissioners. This is very interesting. This is what my professor at Harvard Law will call, Petitioner will call constitutional chaos. So they tell you there is a role to be played by the constitutional body. And then they say, once you establish there's a role to be played by the IEBC, IEBC cannot play that role. Your Lordship, in Peter Gatirao Munya, and this is a point that has not been made by most of the council, the issue of conservatory orders is not for the benefit of the private or the public party. Conservatory orders is for the benefit of the court. Because of the court. Just that. If a party benefits because of that, that is collateral. And that is really important for this court. Because once you establish it's for your adjudicatory capacity, two things fall away. The first thing that will fall away, if you find that there is a remedy, there is an alternative remedy. The second aspect that will fall away, if you make 45(7) of the Constitution, if you make a finding that there is no other way that this court can interpret, X, the president shall cease to hold office. Constitutional injunction, mandamus. So if those two findings are made, then there is no way the petitioners can establish the nugatory aspect. As it relates to the two issues, the gravamen of dispute, the position of the IEBC is that the IEBC does not play any role as it relates to vacancy through impeachment under Articles 99 and 137 of the Constitution. There is no constitutional role for the IEBC. There is no statutory role for the IEBC, and I'll come to that because we spent quite a bit of time, just like the predicament the court is in, whether it should intervene under 165. We also had that predicament. Is there a role for the IEBC? That is the question the CEO of the IEBC asked. And we came to the very considered conclusion, there is no role for us because of constitutional design. And I'll come to that constitutional design. Unlike the court, the IEBC has been involved in a lot of litigation against itself. And there is directions from the Supreme Court of the Republic on what IEBC can do and what IEBC cannot do. I want to refer the court to paragraph 13 of our submissions, the BBI case, the Supreme Court one. And IEBC here can be substituted also for this court, because this court is a creature of Chapter 10 of the Constitution. The IEBC is a creature of Chapter 15 of the Constitution. And this is what the Supreme Court says. At paragraph 13 of we've quoted it verbatim. Number one, the Supreme Court said the IEBC, being a creature of Constitution and statute, could only discharge mandate vested in it explicitly by law. This court, being a creature of the Constitution and statute, can only discharge mandate vested in it explicitly by the law and the Constitution. The second one, which is very important for this court, is the court said that this was direction given under Article 10(2) of the Constitution and the aspects of rule of law under Article 10(2). The third point that the court made, the IEBC, like other public bodies, could not by craft of innovation, and this is really important, Supreme Court, the IEBC, like other public bodies, could not by craft of innovation or interpretation extend its powers. So it is sufficient for the IEBC or even for this court to look at the Constitution, look at the Constitution and the statutory law and not get and exercise what is within the inner boundaries of that. And D, which is to this court, courts should not encourage extension of powers by constitutional or statutory bodies. And this is really important, paragraph 13 of our submissions, Your Lordship. So the constitution of my client IEBC is under Article 88(1), 253, and 259. The position of the IEBC relating to this matter is that Article 149, 145, 150 establish a complete self-contained code. It is a constitutional codified mechanism. It's not a statutory mechanism for governors, for members of National Assembly. It is a constitutional codified mechanism. So when this court is interpreting, IEBC is a creature of the Constitution. This process is a creature of the Constitution. You cannot get out of the Constitution for this process. This court is a creature of the Constitution. So as it relates to the nomination by the President, as it relates to the parliamentary vote, it is not envisaged there is an involvement of the IEBC. This is a constitutional mandamus. As against the IEBC, and I will say as against even this court, we also rely on the case of Engineer Geoffrey Sang versus the DPP and 20 others, your brother Justice Odunga, paragraph 18 of our submissions. And he says that the law is very clear that powers must be expressly conferred. They cannot be a matter of implication. You cannot imply powers. And this is the absurdity. If this court was to make a finding, for example, that IEBC has a role, the way IEBC conducts elections is known, or by elections. So the second order question we'll be asking the court is, do we declare a by-election? Election by its nature is a contest. How will that contest of filling that office be had? Do we print ballot papers? Those are the secondary order questions that the absurdity of the finding of the court that IEBC has a role will entail to. The second thing, our position, is that this constitution is very detailed. It is very interesting. This constitution tells you how it should be interpreted under Article 10. It tells you under Article 201 how the principles of taxation that will apply. It has what we call constitutional carve-outs, the powers given to various entities. It will be high presupposition to assume that this constitution under 149 could have said that this process, it says for even members of National Assembly. It says for members of National Assembly, and even in the elections that we have that. For an office that is that high, there is, to say that the constitution could not have said that IEBC has a role or this court has a role will be a very grand supposition. Your Lordship, we looked at, so we asked the question, what the court should ask. If someone said IEBC has a role, we looked at the things that we will look at. So we'll say, what did the framers think? Can we look at constitutional history to say if there was a role for the IEBC? The IEBC looked at the Bomas draft, Article 168. It looked at the Wako draft, Article 159(1), and we looked at the Harmonas draft. And in all of them, there is no role for the IEBC. So even by constitutional history and constitutional design, there was no role for the IEBC. In fact, there was a role in the Wako draft for the Supreme Court, and those submissions have been made by Mr. Mudomi Tiankulu.
Thank you.
Your Lordship, just 1 minute, I'm almost winding up. Your Lordship, for you to, and then there's a second issue, and then the reason why the court should not interfere with this process, especially I would find there's a role for IEBC. For you to make a finding, for you that the first finding that you have to make, there is first, the people who hold public office, they hold what we call RETAC relationships. These are relationships of trust and confidence within our constitutional architecture. Relationship of trust and confidence within our constitutional architecture. So you have to make a finding first. There is a property in public office. Okay, number one. And that confidence is to the Constitution. Number one, you have to make a finding. There is a property to hold in public office. Okay? Even when there is a breach of that trust. And a finding has been made by other organs of the Constitution. And the court, the test has always been threefold. Number one, total interference. Judicial fear. And we don't do that. Our courts don't do that. Courts don't substitute their preferences to what other organs do. The second aspect has been total deference. Not to what other organs do, but total deference to the Constitution. And this is very funny. Professor Gideon Muigai is here. I used to teach first year contract, and the case of Feldhaus versus Binley came to mind, that the Constitution is silent, so that means that we can read into things, or we can tell the court to intervene. The Constitution is silent on the court intervention under 149, so we read into it. So that's the second aspect. Total deference, if there is a constitutional injunction, constitutional mandamus against a public body or against this court, then the court should be able to deal with that. The third one is the intermediate test. And this is what the court has applied, Your Lordship. The intermediate test is you do procedural constitutional compliance. This is our authorities in E181, Justice Majanja's judgment in the Finance Bill Act. In fact, the decision of the Finance Bill Act Supreme Court came down a few hours ago. I think we provide to the court should look at it. It's even lower because of that. And look at that decision which we provided to the court. The court does what we call procedural constitutional compliance. And what is that? You look at whether a vote happened and the threshold within the constitution have been made. No more than that. And that is supported even by the decision of the Supreme Court, which came down just a few minutes ago. And I want to read a small excerpt, Your Lordship, of that decision, which we have provided to the court.
Which one are you talking about?
I'm talking of the, it is Your Lordship, the citation is E031 of 2024, consolidated with E032, E033 of 2024. Came down just a few hours ago. And I will just refer them.
How is it reported?
It is reported as E031. Let me just it's not yet reported, but it is petition number E031 of 2024, Cabinet Secretary for National Treasury versus Okia Omtata.
Petition number?
E031 of 2024, as consolidated with petition number E032, E033 of 2024, Okia Omtata, the Cabinet Secretary for National Treasury versus Okia Omtata. I argued that matter. I was led by Professor Gidu Muigai. Mr. Ochiel Dadby is there, he can rebut, but he was part of those proceedings. So the threshold is even lower for public participation, number one. That is something that the court has to look at. But importantly, what did the court say about interference at paragraph 208? And I will end here, Your Lordship. Paragraph 208, the Supreme Court of the Republic it quoted the case of International Trade Administration Commission versus South Africa, and this is what it said. I'll just read a small excerpt. Where the Constitution or valid legislation has entrusted specific powers and functions to a particular branch of government, courts may not usurp that power or function by making a decision of their preference. I think that is good law for you.
It's basic administration.
It is a direction to you. And if you look at that case, if you look at Peter Munya, if you look at the negatory aspect, and if you look at the fact that there is at what the submissions of Hussein Marjan and our submissions, you will find there is an express constitutional injunction against interference, not only for this court, even against IEBC. Because if you told me this is an election you are able to clear, then I'll tell you, how am I supposed to conduct this nomination process? And what are the constitutional orders flowing from that? Your Lordship, our submissions are sufficient. I am being told to step down, but thank you so much.
Who has told you?
No, I was being told by Professor Gidu Mugai. My professor is telling me to step down. But if I can, just a second.
Okay, you can step down.
Yeah. Not the court, but Professor. But our submissions are those ones. They are on record, and even if there is a role to be played by IEBC, our position is those are administrative roles which we could still play, and that is provided for under Section 11 of the IEBC Act, Section 13(1) of the IEBC Act. The role that we have to do under 137 is to check the voters register, and we check voters register for even people who, for Kenyans every other day. It's a public document. There is no role for the IEBC to play, and if the court were to make there was a role for us, then we say those are administrative roles, but the court should not find a role for us.
This subsidiary authority you have quoted of E031,
I will. It is hot off the press. I will submit it just now.
submit to our assistance.
I will, Your Worship. I will. Thank you so much, President.
My Lord, I want to apologize if I appear taking the issue of discretion from you. It was intended to keep my promise to you that we will complete.
We now get to know that every side has a prefect. This side, the prefect is Professor Gidu.
My Lord, just want to also add my voice
with the submissions that have been made by the respondents. We should go on record that my name is Shara, I'm the Solicitor General for the Attorney General, together with Professor Gitu Muigai and Charles Mutinda and the rest of the team. Yes, my Lord, to say one or two things so that we wrap up submissions from our end. My Lord, it is not in contestation that under Article 145(7) of the Constitution, a final decision of impeachment was made. It is not in doubt, and that has not been controverted by either side.
No, we have. That is what we have challenged.
A final order to this, my Lord, was made. Secondly, my Lord, it is also not in contestation that a vacancy has arisen or arose in the office of the Deputy President. It's also, my Lord, not in contestation or in doubt that Article 149 of the Constitution was invoked in terms of the President nominating Professor Abraham Kithure Kindiki as a nominee to that position, and that Parliament voted on the same. And I would agree with my learned colleague who has just left the floor, Mahat, that the framers of this Constitution never intended that the IEBC plays a role when it comes to the issue of impeachment. And my Lord, if they so intended, nothing could have stopped them from expressly stating that position. And therefore, my Lord, I am submitting that the interim orders that were granted and are in place cannot cure that position. And therefore, my Lord, relying on the various authorities that have been cited, and more particularly, my Lord, the Munya case, which is a classic case in terms of what will be required in the grant of conservatory orders. It is my humble submission, my Lord, that that has not been made. And I would also submit, my Lord, that when you look at the greater public interest, my Lord, we want to persuade you with the very many other arguments that have been given by my learned colleagues, that you will find favor that the discharge, the vacating, or the varying the orders that have been in place would find greater good than holding those orders in place. And therefore, my Lord, to conclude, I would urge my lady and my lords to find that we cannot continue holding the country at ransom. We need to make a decision that some of the roles and the responsibilities that are played by the President, which are currently at a standstill, would be extremely critical that the moment these orders are vacated, the rest of the processes should be allowed to be completed. I therefore humbly submit that you discharge the orders that are in place and allow the entire process to be completed. I submit, my Lord.
Thank you. My Lord, I want to confirm on behalf of the respondents that we rest there, but with your kind indulgence, if there is to be a reply, I think again we need to remind ourselves that it ought to be on points of law. If the case is rehashed afresh, we would still be here tomorrow and it would contrary to procedure.
My Lord, I also request a direction on whether persons who are not parties to the application, because there are only 2 applicants, have a right of reply, because my understanding is that the only persons with the right of reply are the parties who filed the application, not the entire coterie of this side.
Thank you, Dr.
Okay, 2 things.
Why are we being preempted?
No, 2 things on way forward. I think we still have to hear interested parties, or we have done.
We did that.
We'll finish with yes, now, the right to rejoinder is only limited to the applicants and not any other person supporting the application. So it will go only to the applicants. And in this case, we have 2, and they will have how much do you think?
You have given us 30 minutes. I am addressing the court, please. Yes. Reply to the court. You have given us 30 minutes.
That's okay. My Lord, do we do 15 or 20?
No, my Lord, there is a lot as we can pass. In fact, they have given us the impression that they will read later than now. They have obviously done 4 hours and something. We on the worst things that we can do within 30 minutes. Let's or less, depending on how much he's able to cover. The only issue, my Lord, that is the mischief is that since this is a court of record, we do not want to be accused there is anything that needed a response that was not responded to. Otherwise, I'm very tired. We don't want to be here forever. So we just are here to do the business and we go.
Okay, this is the way forward. We will give the respondents the time, maybe 30 minutes. Not the respondent, but the applicant. Let's go.
I don't may please the court. Because I'm on the same issue. Because I've been standing and I did catch your eye. Still on the issue of the right to reply. My lords, you might remember that I am, first of all, I am one of the represented petitioners of Petition 11. And for the my lord, you might remember that for the last 2 weeks when this matter has been being handled, I have been insisting that we made an application for conservatory orders prior to even the applications we are discussing now, and it was in the best interest of all of us that when discussing the conservatory applications, we be treated as respondents. My lord, unfortunately, when the court gave directions, it consolidated all the petitions, but did not give directions on how our applications would be had.
Now, Mr. Bosso, just a minute. We will restrict ourselves to the applications at hand. So if yours is not among the 2 applications, then you may have to address that later, not now. And the rejoinder should be on points of law. Rejoinder should be on points of law.
My lord, I stand guided, but I'd still wish to point out that there are very specific issues that I raised that were not raised by the other applicants, and which the other side has responded to, and would leave the issues unresponded to altogether.
You can pass those submissions to the council for the other applicants.
My lord, before our council proceeds, I am Mwangi Munga, counsel for the 43rd petitioner, Mr. Morara Omoke. and we also had an application which we believe we have a right to rejoin that, a brief rejoinder. And it was one of the applications that was canvassed. So we also have a brief right to rejoin that. It will only take 5 minutes.
My Lord Morar appeared in person and argued his own case.
And I am his counsel. We are here together with him in this matter.
Let us give directions and we will proceed with these directions which my Lord Judge very much going to give. There must be order in every proceeding.
We start together. Mr. Yes, proceed.
My Lord, my name is Ochiel, and it's a great privilege and honor for me to appear before you and to make the Deputy President's rejoinder. Ochiel Dudley is your name. My Lord, allow me to begin with where my very good friend Mr. Somane stopped. I think he intended to cite to you paragraphs 209 and 210 of the Supreme Court decision. He stopped at 208. I believe that was a mistake. Because if you look at paragraph 209, this is what the Supreme Court has said this afternoon, that the framers of the Constitution made it possible for litigants, like our client, the Deputy President, without exception, to approach the courts for redress of fundamental rights and on issues concerning interpretation of the Constitution to determine whether any law or anything said to be done under the authority of the Constitution is constitutional. Paragraph 210, Supreme Court, this afternoon, the court says that this constitutional inquiry, the inquiry you're involved in, extends. The court, while conducting this inquiry, should bear in mind the unlimited reliefs contemplated under Article 23. Although that's sufficient to clear any doubts about your jurisdiction and to clear any doubts about your power to give conservatory orders. If there are any doubts, the court should now feel comfortable. Now, during the break, I inquired for my learned friend, Mr. Thiankolo, a very good friend of mine, and I asked him, Dr. Thiankolo, who is the governor of Meru County? He told me, Kawira Mwangaza. Then I asked him, by what authority?
Is he still submitting on points of law, my lord?
Yes. You want to hear? When I asked him, by what authority? He told me, by a conservatory order. And so, my lord, this court can give conservatory orders against impeachment. The conservatory order we are speaking about, the one I was speaking to my colleague about, was given by this court not so far ago, on the 21st of August, 2024, in petition E429 of 2024. Let me come to the other case, the Kisii governor's case. Lord Justice Ogola, you are familiar with that case, you're not a stranger to it. Because at some point you gave directions indicating that you would not interfere with the conservatory orders in place, and that that matter would come before Justice Okwan, which is a decision my learned friend, another good friend, Mr. Nyamodi, spent a lot of time on. My lord, that case is different from this one on the issue of delay. Under Section 32D of the County Government Act, a vacancy in the office of Deputy Governor must be filled in 14 days. What did Purity Mora Kirera do? She filed her petition on 1st of April 2024. The Senate impeached Dr. Robert Monda on 14th of March 2024. So she was coming to court outside the 14 days. My lord, in this case, we have 74 days under the Constitution, Article 149(1). Those 74 days have history in the constitutional text. My lord, if you look at page 233 or the CKRC final report, you find Kenyans speaking about, my lord, the need to allow the transitional processes to be disputed. My lord, the Constitution gives a lot of 14-day timelines, but in this case, it gives 74 days. And we submit that the purpose of that is to allow aggrieved parties to come before the court like we have. And so, my lord, on the issue of delay, which is a distinguishing fact, which is why the court did not give Kirera conservatory orders, but gave Mwangaza conservatory orders, is that the 14-day period had expired when the petitioner went to court. And allow me to concur fully with two things that my learned friends, Mr. Nyamodi and my good friend, Mr. Somani, said, that conservatory orders are ready for the court because the court has a duty under Article 23 to fashion appropriate reliefs. Conservatory orders, as they said, help the court to preserve a matter. And the matter to be preserved there is an impeachment both of the National Assembly and the Senate, and the subsequent nomination of Kithure Kindiki to the office of Deputy Governor. And again, unlike Mora, he is yet to take oath here. So the subject matter before the court is still live, and you can and need to preserve it. Lord, on the nature of conservatory orders, I agree fully with the submissions of the Attorney General. The case they cite, TSS spinning, helps the petitioner more than it helps the respondent. Because in TSS spinning, the court says that conservatory orders, as tools for preservation of the subject matter, hold the subject matter in situ. They maintain the situation of the subject matter before the mischief crept in. The mischief crept in here when Wendy Mutuse filed his motion. So the conservatory order preserves that state of affairs. It takes us to the point before the mischief crept in. More mischief will creep in if, despite this litigation, Kithure Kindiki is sworn into office. Other cases we agree with, cited by the National Assembly's Gitari Industries, helps the DP on the point that conservatory orders are tools for preservation of a particular state of affairs. A particular state of affairs, which so far you preserved, is that our client is a deputy president of the Republic of Kenya. We ask you to sustain this conservatory orders. My Lord, County Assembly of Embu, argued by the Supreme Court, is distinguishable. In that case, the Attorney General told the Supreme Court that if a vacancy occurs mid-term in the office of Deputy Governor, then that vacancy would remain to the end of the term. The vacancy, paragraph 28, County Assembly of Embu, the Attorney General told the Supreme Court it would remain to the end of the term, it would remain unfilled. That time, we had not yet amended Section 32, Capital B of the County Governments Act. It was amended in reaction to this Supreme Court case. And so the Supreme Court, to that suggestion by the Attorney General, says that no, we cannot have an indefinite vacancy in such a vital office. That case is distinguishable. I reiterate that the timeline we have here is 74 days. We're yet to eat into a quarter of those days, my Lord. And from the posture taken by this court, it's possible to hear this case and conclude it within those 74 days. My Lord, this petition, within those 74 days, all the three chains of Kenyan's court, when required, have risen to the occasion. BBI did not last the 3-5 years my friend Mr. Giancolo spoke about. It lasted a matter of months. And so it's possible for this court to hold things in place and to expedite the main petition. My Lord, unless that happens, my becoming friend, Professor Gideon Migai, spoke about the dissipation of the subject matter. He said this has already dissipated. My friend, Professor Gienda, said, likened it to a death which has already occurred, and so there's no coming back from it. The Senate, in their submission, suggests damages. The petition does not plead for damages. In short, my Lord, if at this stage the respondents can tell you that the court cannot craft remedies, Dr. Fiancol bases his preliminary objection on that point. He says that you should not touch this dispute because you would not be able to craft any remedies after hearing the case. My Lord, if at this stage, before you hear the case on the merits, you can be told that what would happen when, without conservatory orders, you hear the case and the petitioners succeed? My Lord, as I move to conclude, the Attorney General urges you to find, on the basis of the vacancies in the IEBC, that there's public interest in allowing the process to conclude. My Lord, there is an authority, a court order by this court in proceedings to which the Attorney General was party. The Attorney General, in January of this year, 26th of January 2024, in the Banisa case, the Abdullahi versus Attorney General, was directed to reconstitute the IEBC. He has not done that. Today, the Attorney General stands before you and tells you that on account of his delict, on account of his and his client's contempt of court, you should exercise your equitable discretionary remedy of conservatory orders in his and his client's favor. My Lord, a party cannot benefit from their own wrongdoing. That fact of vacancy in the IEBC against an order of this court should not be evaluated in favor of the Attorney General and to the disfavor of the petitioners.
Mr. Dudley,
My Lord,
are there any pending litigation on the IEBC court?
there are, yes, my Lord,
Yeah.
but this order has not been stayed. It has not been appealed.
That's okay.
Yes, my Lord. My Lord, there's a case that we did with my good friend Mr. Adrian Kamodo. It's called Itubi versus Law Society of Kenya, where Justice Omudi gave directions and orders to maintain the status quo pending the determination of the matter in court. Itubi, through my good friend Adrian Kamodo Njenga, went to the Court of Appeal. The Court of Appeal, my Lord, affirming those orders, found that it was an act of mischief to ask the Court of Appeal to vacate conservatory orders meant to preserve the status quo pending the hearing of the matter in court. We submit that the application to vacate made before you is an act of mischief. There's another case, my Lord, on this issue of vacating conservatory orders. This case was argued by my good friend Mr. Nyamodi when he was still on the good side of things. And Professor Gideon Migai was also in it. Those days, Nyamodi was a good guy. He had not joined the bad company of Mr. Gumbo, who is my friend. This is what the Court of Appeal said. The Court of Appeal said that...
Lobby must be a bad guy if Gumbo is bad and his friend.
The Court of Appeal said, my Lord, that when weighty challenges have been placed before you, before a court, and the court has issued conservatory orders, one requires a very strong case to lift those conservatory orders. My Lord, a very strong case has not been made before you to lift the conservatory orders. Instead, a very strong case has been made to sustain and to affirm and to reiterate the conservatory orders. My Lord, I close with the issue of public interest. And again, thanks to the doctrine of precedents, you do not have to think too hard on this. In Attorney General versus Martini, shutting out 50 CISs whose appointment was questioned before the court, the Court of Appeal, my lord, said that it would be no consolation to tell the Kenyan people that although service has been rendered, although unconstitutional service has been rendered, it's still service. The Court of Appeal said, my lord, that service in violation of the Constitution is no service. And in a case that Professor Ojenda argued, the Ongo case, when
I didn't cite that.
I am citing it, well, I am citing it in the reply.
In response, but I thought on points of law, you refer to cases that have been cited by the other side.
No, I didn't cite it.
You can't pick up my case. I didn't have it.
My lord, if he didn't argue it, he should have argued it. This is a point. My lord, you are told about the public interest. The Court of Appeal in Ongo.
He cannot, I think he cannot argue the Ongo.
Because otherwise he also have the right to
Yes, I will.
and will hear from much better time.
Back and forth. Just leave on
That will help from the law. How we have, for example, presented to you the Supreme Court President. Because the purpose of rejoiner as well, my lord, is to distinguish and to tell the court points which the other side have concealed.
Well, you say it, then we'll give him a right of and apply on that issue.
It's in our submissions.
Do you accept that we'll give him a right of reply on that issue?
On this case, yes, my lord, because it's in our submissions. The law case is in our submissions, my lord, and they can distinguish it very shortly. And the court said, in short, that it is in the public interest to keep out a person if the validity of the appointment is questioned. He had wanted his client to assume office despite a court order to that appointment. And so, my lord, the office here is a high state office. If Kithure Kindiki assumes office, he will make directives, he will make policies, he will commit omissions. My lord, this court is yet to design a mechanism for reversing the policies, the decisions, the directives that you will make. If at the end you find that the impeachment and the nomination were both unconstitutional, the Constitution would have been irreparably violated. And my lord, I close on the point that this case is arguable. In fact, the courts had to stop Mr. Milimo many times and was lenient to many others of my colleagues who strayed into the merits. Prof. Ojenda being at the forefront of that. The council argued the merits on both sides of the aisle. And so my lord, that demonstrates that parties are biting at the bits. They are ready to argue the petition and will do so at the earliest opportunity. We request you, my lord, to allow the request for conservatory orders to please preserve the dispute and let our appearance, our further appearance before you be of some meaning under the Constitution. Thank you for the opportunity, my lord.
Thank you.
May I donate, if I still have it, 3 minutes to my colleague, Mr. Gachagua'S.
Lordship, I will be brief. I want to respond to the following points of law raised by the other side. From the other side, a lot of hue and cry has been made about Article 145, Clause 7, and the word shall. Lordship, the Black's Law Dictionary, Brian Garner, 10th or 9th edition, confers 6 different meanings to the word shall. So from the plain text meaning of the word shall, the dictionary in law gives it 6 meanings. So shall cannot only mean mandatory, it can mean any other thing. Black's Law Dictionary. In terms of the reading of the Constitution, The Constitution can be read multiple times. It's not only the textual reading of the Constitution that counts. If I had time, I would share with my friends that we drink uji once in a while on the other side. There's a book by Professor Philip Chase Bobbitt that canvasses 6 methods of reading the Constitution: textual reading, moral reading, structural reading, doctrinal reading, purposive reading. Purposive reading has been read in our Constitution, Article 259(1). It has about 4 elements. If we go to 259(3), living tree reading, first articulated by the case of Edward versus Sankey, 1930 Canada. What does that mean to this honorable court? There is more coming. So while they were telling us that we are running away from the case, they're telling them, we are ready, and we're going to explore the full depths of this Constitution on the merits. Please consult the substander. We are ready to go. The question, another point was raised here, that the President is protected by the Constitution in his role in appointing a prophylactic Deputy President in a nominating capacity, normative capacity. The Constitution in that manner is deemed as a constitutive charter. It creates institutions. The Constitution, going by the violations that have been raised on this side, touching on constitutional rights, plays a protective capacity. So this court will, on the merits, be asked to balance those 2 shades of the Constitution. The Constitution as a constitutive charter, the Constitution as a protective charter. We will discuss that on the merit. My good friend, Senator Professor Tom Ojenda, expert orders need to be lifted for the reasons he raised. They have not answered to you, to your satisfaction, and we attached a case in our submissions. There's a decision of the Ghanaian Supreme Court, Barclays Bank, in our submissions. The test for overturning a decision made ex parte. They have not satisfied you as to why the decisions of Justice Mwongo in Kerua should be overturned. The issue here is broader than mere compensation by way of sums of money to an individual. The broader question here is the Constitution and how offices of the Constitution are occupied. Article 1, Article 2, Article 3 of the Constitution. My good friend and teacher, Bubomi Thiankolu, that there is an absence of a specific textual authorization for judicial involvement in the court. Again, we refer to the various methods of reading the Constitution, so that if we go by their own arguments, and I had my good friend Mr. Somare talk of reading in, that's a remedy available to this court under Article 23. Reading in can't be read into statute or any other constitutional methods here. We can use that as a remedy. So the absence of express textual bar in the Constitution does not preclude this court from reading the Constitution in any other way. Several documents are cited here, the Bomas draft, the Kilifi draft. What was missing from all that discussion is the commentary from individual delegates. Because if we were to look at the travaux, the preparatory documents, where are the comments from the delegates? Where is the report of for the Committee of Experts? And in any case, the Constitution 2010 enjoys its imprimatur, its force in law, by the seal of approval it was given by the citizens through a referendum in August 2010. And any law interpreted and read into the Constitution post the promulgation, that becomes law. These courts have been laboring to do that for some time. Finally, Mr. Milimo, the Senate sits in a quasi-judicial capacity. Yes, the Senate sits in a quasi-judicial capacity, Article 47 kicks in. This court has to exercise judicial review. Madison versus Marbury, 1803. It is inherently the province of the judicial branch to say what the law is. I submit.
My Lord, for purposes of the second application, Mr. Mbegwa will, in about 5 minutes, will make some 2 points, then I will proceed with the remainder.
Thank you very kindly, my Lord Smiley. Permit me just to indicate what Professor Idhu Muigai Senior Counsel indicated, that the Senate is a chamber or is a political chamber. There can never be something that is far from the truth, because in the case of Governor Wambora, that is civil appeal number 21 of 2014, the Court of Appeal had the opportunity of evaluating that proposition, and it came to a conclusion that when the Senate is seized of a matter of impeachment, it's not just a political chamber, but it converts itself into a quasi-judicial process. And that is why, my lords, under Standing Order number 79, the Senate is required to take a special oath before constituting itself into a quasi-judicial chamber. On the question, one issue about justiciability of the process, it's our humble submissions, my ladies, my lords, that was ousted by the enactment of Article 3, Article 1, Article 10, 27, 25, 50, 165, and 159 of the Constitution. When the people of the Republic of Kenya enacted Article 3, it bestowed upon all state organs, any individual, to protect the Constitution. And therefore, there is nothing that is far from the reach of this court, insofar as the protection of the Constitution and Article 3 is in issue, insofar as the upholding of the doctrine of sovereignty is in issue, insofar as the application of Article 10, the principles of and the values of governance are concerned, and most importantly, the rule of law. How can it be that justiciability can be pleaded as a defense, yet the court is being told to uphold the rule of law, good governance, democracy, and the participation of the people? How can it be that this can be a defense when Article 165, 3D calls upon this court to interrogate whether anything said to be done has been done in accordance to the Constitution? Was the impeachment of the Deputy President not done within the Constitution? Was it not sanctioned by the Constitution? How then can it be from the reach of this court? How then can it be a defense when Article 27 creates a doctrine of equality before the law? How can it be argued in that respect? Allow me to address what Professor Ojienda addressed. The question of the two-tier trial. Yes, it was a two-tier trial, but was the Deputy President granted an opportunity to be heard? My lords, my ladies, look at Article 1 and Article 94 of the Constitution as read together. Article 94 provides for the creates Parliament and provides that it's a representation of the people. How can it be a representation of the people and you lock them out when it comes to their participation on a question of the impeachment of the Deputy President? How can it be that Parliament can be immune from the application of Article 1 and usurp the people's power when the people are supposed to directly participate in giving their views under Article 118 of the Constitution? Well, ladies, my lords, you are invited to look at the trial at the Senate, and you are told that it was time-bound. My ladies, my lords, it's a misconception and misreading of the Constitution under Article 147, 145. My ladies and my lords, the only time Senate was limited was when or if it constituted itself into a special committee. if what transpired in Parliament, in the Senate, was a matter that was under Article 145, Clause 6, then we could say that the 10 days period mattered. But it is important for us and imperative for us, my ladies, my lords, to note that when the Senate sat to hear the impeachment of the Deputy President, it is sat as a plenary of the House. And as such, the 10 days were not therefore applicable in that circumstances. Number two, my ladies, my lords, you have been told that the Deputy President avoided to appear for his defense and that he was represented. But my ladies, my lords, if my good learned friend Professor was candid with the truth, he would have drawn your attention to the provisions of the rules of procedure for the removal of the President and Deputy President, Standing Order number 78/9, and you'd have drawn your attention to rule number 6. And on that rule number 6, he would have told you that the rule provides that where the President chooses to appear before the Senate, the President shall be required within 3 days of the invitation under sub-rule 4, rule 4 on the date specified in the invitation to file an answer to the charge with the office of the Clerk of the Senate, in which the President shall set out. He would have told you the mode of appearance. 1, the President's response to the particulars of the allegations. Number B, how the President, and in this case the Deputy President, proposes to appear before the Senate. And that rule has created through mechanisms or through 3 ways in which the Deputy President could have appeared. 1, whether in person. 2, by advocate. 3, in person and by advocate. The operative word in our case, my ladies, my lords, is number 3, in person and by way of advocate. The Deputy President appeared in person and by advocate. And as such, my ladies, my lords, when he was taken ill, the question of then appearing in person and by advocate was an issue. And number 2, my ladies, my lords, he was a witness and the only key witness before the Senate. How then could you say that there was fair trial under Article 50 of the Constitution when the only fundamental infrastructure of the trial is unavailable? My ladies, my lords, permit me to address you on what was submitted by Mr. Somane. It's unfortunate that he has chosen to have a very lean and thin way of looking at the application of Article 149 of the Constitution. There can never be anything that is misleading to say that that article should be read in isolation of other provisions of the Constitution. If you choose to read Article 149 in isolation, you arrive at the absurdity that Mr. Somane and his colleagues have arrived at. I would urge this honorable court to look at the import of Article 259 of the Constitution, which provides for the manner in which the Constitution must be interpreted. If Mr. Somane was candid with the truth, he would have invited this honorable court to harmonize and to purposively read into Article 149. My ladies, my lords, the reading of Article 149 in a purposive and in a harmonious way would have told Mr. Somane that then Article 99 and Article 137 of the Constitution is imperative. And therefore to say that the IEBC had no role in the process of the nomination of Mr. Kindiki is absurd, is not true. The fact is that if Mr. Kindiki was to successfully become the Deputy President of the Republic of Kenya, is it then true that he can become a Deputy President who has not qualified under Article 99 of the Constitution? Is it therefore true that he can become the Deputy President if he has not qualified under Article 137 of the Constitution? Who then determines this qualification? Is it the President? Is it Mr. Somane? Is it Ndegwa? Who determines that qualification if it is not the IEBC?
My Lord, there is something that Mr. Giru is submitting on.
which touches on very critical facts concerning Professor Kindiki as to his qualifications. And we are all familiar with the qualifications of Professor Kindiki.
I think the last time Mr. Kamodo was before you, he said he has no client.
I have a client, the 10th respondent, the United Democratic Alliance. I ceased to work for the other client because it would have been illegal. But I have a client. So I'm properly on record. And it is important that the record be very straight with regard to Professor Kindiki's qualification and including what had been cited in the affidavit that he was not a member of the UDA for 3 months, which is not a requirement in law. No law requires you to be a member of a political party for 3 months for you to ascend to the position of the deputy president, which Professor Kindiki has acceded to. And secondly,
that's a merit issue that is being argued. So we're going to have the opportunity to answer it, because the law is the opposite of what you say.
It was raised by Mr. Giro, I'm just clarifying.
This is not the time to raise that issue. That is my submission, my law. He is going into the merits.
But then Mr. Giro may
just let's sort it. My lord, it's news on record for Professor Kindiki. I think if Mr. Debo Giro, my very good friend, I usually call him the Black Bull, could keep off rehashing his application.
The black what?
Bull. That's what Debo Giro means. If my friend, the Black Bull, would keep within the remit of a rejoinder and a reply, will not be having all these interjections. I have been resisting that because I always try to avoid appearing cantankerous. But if he keeps rehashing his application, unfortunately, then as the person on record for Professor Kindiki, I will be forced to be cantankerous, which is not my nature.
Let's give Mr. Giro time to.
I am most obliged, my lords. My lords, finally, let us distinguish the Kisi case from what is before you. What is before you, my ladies, my lords, is a case where a party was not granted an opportunity to be heard. It is a question where there is a violation of Article 27, violation of Article 10, violation of Article 50, and violation of Article 25, that the right to be heard cannot be derogated. What was in Kisii, my ladies, my lords, is that the Kisii deputy governor underwent the full trial at the Senate. And therefore, my ladies, my lords, those facts are distinguishable. Finally, my ladies, my lords, Mr. Gumbo urged you to fight that there will be crisis if the position of the deputy president is not filled. I want to remind him that Article 139 and Article 146 has created an avenue and a remedy where if the president is given today impeached, the remedy is that the Speaker of the National Assembly under Article 146 takes over for 60 days, and under Article 139, if the two of them are not able to take office, again the remedy is that the Speaker takes over. So we are not in a crisis whatsoever, my ladies, my lords. I invite my learned friend, Senior Mr. Kibe, to proceed.
My Lord, I start with the assurance to my learned colleagues that I know what is replied to issues of law. So I hope I can proceed without a lot of interruptions. My Lord, I start with the submissions by my learned colleagues, Professor Muigai. I agree with him, my Lord, that you cannot be able, we are entitled to a legal opinion, but we are not entitled to a set of facts. And therefore, where the set of facts is as they are. But my Lord, in saying this, it is important to remember that what also litigants are not entitled to, and this is the reason for conservatory orders, is the fact that unlike in war, where you can change facts on the ground, the court does not accept a situation in which one party
would be allowed to change facts on the ground in a manner that makes a mockery of the proceedings before it. That is to say, if we are before you on account of the fact that there have been violations in the impeachment process, my Lord, and the conservatory orders that have prevented the completion of those illegalities are in issue, this court should not permit a situation in which a party is able to say that let me change certain facts, as it were, by completing the violations. My Lord, there is a question of public interest. We don't have to say much about it, but coming from the Honorable Attorney General, my Lord, I would only urge that public interest from the Attorney General must also be read, apart from what is directly friendly to the government, must also be read to what is also friendly to the people of Kenya. And that is a desire to ensure that the impeachment process is done credibly and upholding all the rights and the procedures that are in issue, so that it is still possible for the Attorney General to say that public interest in this particular scenario would require that fundamental rights, the case on fundamental rights, be concluded before you can be able to say this or the other person should take office. My Lord, there is the issue of the conservatory orders. I've had to read them again. The one from Justice Muongo, because they have been called as orders of reinstatement or mandatory mandatory injunctions. My Lord, I believe and I have a lot of full confidence in the fact that it will not be possible for Judge Muongo to issue mandatory injunction on reinstatement at that level, and as a matter of fact, he did not. The prayers as framed is purely to preserve this matter pending hearing and determination of the petition. So it's a scarecrow argument to say you are seeking reinstatement, you are seeking mandatory injunction. There is no such thing, my Lord.